It starts with a contradiction, not a loud one, not the kind that explodes across headlines or trends for a few frantic hours before disappearing. This one is quieter, almost polite, easy to miss if you're not listening carefully. What if the man standing in a London courtroom, blaming the press for the most painful intrusions of his life, already knew, privately, that the press wasn't responsible for at least some of them? But before we continue, please subscribe and turn on the notification bell for updates. That's not an accusation. Not yet. It's a question. And it's the question hanging over London this week as Prince Harry takes the witness box again, voice cracking, jaw tight, eyes fixed somewhere beyond the judge as he describes years of pressure, fear, and what he calls a campaign that made his wife's life an absolute misery. Listen to him, and the story feels airtight. Relentless tabloids. Ruthless intrusion. A young family under siege. A man who has finally decided to fight back, not just for himself, but for something larger. Accountability, justice, closure. And if that were the whole picture, this would be a very different video. But journalism, real journalism, begins where the clean narrative starts to fray. It lives in the margins, in the footnotes, in the things people didn't intend to say out loud. Because while the courtroom has been focused on editors, reporters, and newspaper executives, something else has been circulating quietly among legal observers and sources close to the case. Not a new witness, not a surprise filing. Messages, private ones. Messages that, if they exist as described by those familiar with them, don't directly contradict Prince Harry's pain, but may complicate the story he is telling about its cause. And those messages, according to multiple accounts, are linked to someone the public hasn't heard much about in this trial so far. Chelsy Davy. Now pause here. This is where tabloids would usually rush in, grinning, eager to frame this as an ex-girlfriend drama. That's not what this is. Or at least, that's not what it becomes if you slow down and look at the details. Chelsy Davy isn't reappearing in this story as a romantic footnote. She matters here, allegedly, because of timing, because of access, and because of what she may have been told, privately, at moments when Prince Harry believed he was speaking off the record, beyond the reach of courts and cameras. And again, we need to be careful. Everything you're about to hear is framed as claims, allegations, and accounts described by sources familiar with the material. No court has ruled on these messages. No judge has weighed their credibility. They have not yet been entered into evidence, if they ever will be. But their existence alone is enough to raise a question that won't go away. If Prince Harry privately acknowledged that specific leaks came from inside the palace, not from journalists, why has the legal battle been framed so narrowly around the press? That's the contradiction. And contradictions are where stories like this either collapse or transform. This trial matters right now because it isn't just about phone hacking or unlawful information gathering. It's about credibility, about narrative, about whether emotional truth and factual precision always align, or whether sometimes they quietly drift apart. Inside the London High Court, Prince Harry has presented himself as a man finally drawing a line. He accuses Associated Newspapers, the publisher of the Daily Mail and the Mail on Sunday, of illegally gathering private information, of creating an atmosphere so toxic that it seeped into every corner of his life. Associated Newspapers, for its part, has vigorously denied those allegations. That's on the record. This is an adversarial process, and no outcome has been decided. But what complicates matters is not the denials. It's the timeline. Because timelines don't care how emotional a testimony is. They just sit there, stubborn and silent, waiting to be lined up. And when some observers began lining up the dates of certain articles with the dates of private communications, again, allegedly, something felt off. Not dramatic, just off. A few days here, a message there, a call that didn't quite fit the public version of events. Ask yourself this, honestly. And I mean really ask it, not rhetorically. If you were under siege by the press, truly convinced they were the source of your suffering, would you privately tell someone else that the information actually came from inside your own institution? And if you did, what would you do with that knowledge? Would you confront it? Expose it? Or quietly set it aside, while pursuing a broader war against an enemy you believe deserves to be challenged anyway? This is where the story stops being about villains and heroes and starts being about human behavior under pressure. Prince Harry's testimony this week has been emotional. There's no disputing that. At one point, his voice reportedly faltered as he spoke about Meghan Markle, about the toll the media attention took on her, about watching someone he loves struggle under a spotlight he has known since birth. "They continue to come after me," he said, according to Courtroom reports. "They have made my wife's life an absolute misery." You don't have to agree with his legal case to feel the weight of that moment. Pain like that doesn't need embellishment. It sits heavy in the room all on its own. But emotion, in court, plays a complicated role. It can illuminate truth, and it can also, unintentionally, shield other truths from scrutiny. That's not a moral judgment. It's an observation borne out by decades of courtroom history. Juries, judges, and the public are human. We respond to suffering. We lean toward narratives that make emotional sense, which is why the existence of private messages that allegedly acknowledge a different source of leaks, is so destabilizing. Not because they prove anyone lied. They don't. Not yet. Not on their own. But because they introduce the possibility that two realities were operating at once. A public reality, where the press was framed as the central antagonist, and a private reality, where responsibility may have been understood as more complex, more internal, and far less convenient. Here's where things get uncomfortable. If those messages are real, and if their contents are accurately described, then Prince Harry may have been fighting a war fueled as much by belief as by evidence. Belief that the press, as an institution, has caused irreparable harm. Belief that taking them on is necessary, even if the facts in specific instances don't align perfectly with that larger mission. That doesn't make him malicious. It makes him human. But it does raise a question the court cannot ignore forever. At what point does selective framing become a problem? And what happens when someone outside the courtroom spotlight, holds pieces of the story that don't quite fit? Chelsy Davy, according to those familiar with the alleged communications, didn't go looking to become part of this. There's no suggestion she sought publicity or leverage. If anything, sources describe her as reluctant, uncomfortable with the idea that private exchanges might suddenly carry legal or public weight. And that reluctance matters, because it suggests these messages weren't curated. They weren't crafted for impact. They weren't written with the expectation that anyone else would ever read them. Those are the kinds of messages that tend to be the most revealing, not because they're dramatic, but because they're casual, unguarded, honest in the way people are only honest when they think no one is watching. And that's why, right now, this story isn't about whether Prince Harry is right or wrong. It's about whether the version of events being tested in court is the full version or a strategically narrowed one. The trial is still unfolding. Testimony continues. Legal teams are maneuvering. No verdict has been reached. And nothing you hear in this video should be taken as a declaration of guilt, innocence, or deception. But investigative journalism doesn't wait for verdicts to ask questions. It asks them early, carefully, reluctantly, sometimes. Because once the trial ends, the narrative calcifies. People pick sides. The opportunity for nuance evaporates. So here's the moment we're in. A prince on the stand, fighting a media empire he believes destroyed his peace. A former partner, holding alleged private records that suggest the story might be more complicated. And a court that, sooner or later, may have to decide whether emotional truth can stand alone or whether factual completeness must come first. Because once timelines collide, once private acknowledgments brush up against public accusations, the story stops being about who suffered the most. It becomes about who knew what and when. And what came next may force everyone involved to answer a question they were hoping would never be asked. It begins exactly where the confidence starts to feel too smooth. If you watch the coverage without slowing it down, if you only caught the headlines, the clips, the quotes pulled for maximum impact, you'd think this case was already settled in the court of public opinion. A prince versus a press machine. David versus Goliath. Trauma versus tabloid cruelty. And that's precisely why Chapter 1 matters. Because before any contradictions, before private messages, before unanswered questions, we have to sit with the official story. Not mock it. Not rush past it. Really understand it. On its own terms. The way the court is being asked to understand it. This is the story as Prince Harry tells it. Inside the London High Court, the atmosphere is formal, restrained, almost antiseptic. Wood-paneled walls. Lawyers in dark suits. the careful choreography of a system that prides itself on order. And then there's Prince Harry, sitting upright in the witness box, not as royalty, not as a celebrity, but as a claimant. He isn't shouting. He isn't theatrical. That's important. His tone, according to multiple courtroom observers, is controlled, deliberate, sometimes halting. He chooses his words carefully, as if aware that every sentence might echo far beyond the room. This is not a man improvising. This is a man who has rehearsed his pain, not to exaggerate it, but to survive having to explain it at all. Harry's legal argument, stripped of emotion, is relatively straightforward. He alleges that Associated newspapers, through titles like the Daily Mail and the Mail on Sunday, engaged in unlawful practices to gather private information about him and his family. Phone hacking, use of private investigators, illicit sourcing, a pattern of behavior that, he argues, went far beyond legitimate journalism. Associated Newspapers denies these claims vigorously. That denial is part of the record and must be treated as such. But in this chapter, we're not weighing who is right. We're understanding what Harry is asking the court to believe. He describes a life lived under constant observation, not metaphorical observation, literal scrutiny, headlines that track his movements, articles that seem to know things before he's ready to share them, details that feel too intimate to have come from public sources alone. And then he connects those experiences to a broader emotional toll. This is where Meghan Markle enters the narrative. Not as a co-claimant in this case, but as its emotional center of gravity. Harry speaks about watching his wife struggle with relentless coverage, about fear, about stress, about a sense that no boundary, once crossed, could ever be rebuilt. They continue to come after me, he tells the court. They have made my wife's life an absolute misery. There's a pause there, according to those in the room. A moment where the legal theater drops away and something raw pushes through. You don't have to like Prince Harry to recognize that pain. You don't have to agree with his lawsuit to acknowledge that it sounds sincere. And sincerity is persuasive. That's part of why this case has captured so much attention. Because Harry's testimony taps into something familiar. The feeling of being misunderstood, of being hunted by forces too large to confront individually. He frames his lawsuit not as revenge, but as necessity, as a stand he feels compelled to take, not just for himself, but for others who lack his platform. It's an appealing narrative, almost noble. But here's the thing about narratives built on emotion. They can be absolutely true in one dimension and incomplete in another. Harry describes articles that appeared at moments of vulnerability. Stories that seem to exploit grief, conflict, or transition. He argues that legitimate journalistic explanation doesn't account for how specific some of those details were, how precise, how invasive. And again, on the surface, that argument holds water. Anyone who has followed British tabloid culture knows its history. The industry has been sanctioned before. Phone hacking scandals are not theoretical. They're documented. So when Harry places his experience within that lineage, it resonates. It sounds plausible because it fits a known pattern. But plausibility isn't proof. And courts don't rule on vibes. This is where timing becomes everything. In his testimony, Harry presents the press as the central vector through which harm entered his life. The source of leaks, the engine of exposure, the antagonist around which everything else revolves. He does not, at least publicly in this phase of the trial, dwell on internal palace dynamics. He doesn't center aides, staffers, or institutional leaks as primary culprits. The focus remains outward, not inward. That focus is strategic, and it has to be, because a lawsuit against a media organization depends on showing that organization acted unlawfully. Introducing alternative sources of leaks, especially internal ones, complicates that case. It muddies causation. It creates reasonable doubt. So from a legal perspective, narrowing the narrative makes sense. But from an investigative perspective, narrowing always invites questions. Ask yourself this. When information about a public figure appears in the press, how many possible paths could it have taken to get there? Direct interception, illicit access, anonymous tips, authorized briefings, casual conversations, internal betrayal, accidental disclosure. The list is longer than most people realize. Harry's case implicitly asks the court to believe that, in the most damaging instances, the path led through unlawful press behavior. And again, that may be true. In some cases, possibly many. But the court hasn't been asked, yet, to consider whether Harry ever knew, at the time, that some of that information originated elsewhere. This is the silence at the center of Chapter 1. Because silence is not the same as lying, but it is not neutral either. During cross-examination and testimony, what a witness emphasizes matters just as much as what they omit. Courts understand this. Lawyers exploit it. Judges watch for it. And while Harry's account is emotionally coherent, there are moments where its edges feel carefully sanded. For example, he speaks about articles that seem to anticipate events before they happened. He frames that as evidence of illicit news gathering. But anticipation can come from multiple sources, including internal planning documents, calendars, or conversations with people who had legitimate access. Harry doesn't deny this possibility outright. He simply doesn't explore it. And that choice is telling, not incriminating, not deceptive on its own, just telling. Because if you knew, privately, that at least some leaks came from inside your own institution, how would that shape the way you tell your story publicly? Would you feel obligated to complicate the narrative? Or would you focus on the broader harm you believe the press has caused, even if individual instances don't line up perfectly? This is not a moral trap. It's a human one. Harry positions himself as someone who has finally had enough. Someone who has reached a breaking point after years of restraint. His legal team frames the case as a necessary reckoning with an industry that has historically operated with impunity. And many people watching want to believe that reckoning is overdue. But courts don't exist to validate feelings. They exist to parse facts. And facts have a way of leaking out, even when no one wants them to. At this stage of the trial, the official story remains intact. Harry's testimony stands. The press stands accused. The defense denies wrongdoing. The judge listens. Nothing has exploded. Nothing has collapsed. Which is exactly why what happens next matters so much. Because the most destabilizing revelations in cases like this rarely arrive with sirens. They slip in quietly, attached to documents, messages, or offhand acknowledgments that don't fit the original frame. And somewhere outside the courtroom, not under oath, not under lights, there are alleged private exchanges that may suggest Harry's understanding of these leaks was more nuanced than his testimony implies. Again, not proof of dishonesty, but potentially proof of complexity. And complexity is dangerous in a case built on moral clarity. As this chapter closes, the court remains focused on the press. The audience remains emotionally aligned with the claimant. The narrative feels strong. But just beneath the surface, another version of events is waiting. One that doesn't scream, doesn't accuse, doesn't even demand attention. It just sits there. In timestamps, in call logs, in messages sent when no one thought they'd ever matter. And once those begin to surface, the question won't be whether Prince Harry suffered. The question will be whether the story he told the court was the whole story, or just the part he believed the court needed to hear. And that's where everything starts to shift. She didn't re-enter the story with a statement. No press release. No interview. No carefully worded denial or dramatic confirmation. In fact, if you weren't looking in exactly the right place, you might not notice her reappearance at all. That's how Chapter 2 begins. Quietly. Almost accidentally. Because Chelsy Davy does not step back into this narrative as a character seeking relevance. She appears because the past has a way of resurfacing when timelines are tested, and because private conversations, once thought harmless, can become something else entirely when the present demands answers. To understand why Chelsy matters here, you have to strip away the public mythology that has grown around her. The woman who walked away. The one who couldn't handle royal life. All of that is noise. Familiar noise. And useless for what's unfolding now. What matters is this. Chelsy Davy knew Prince Harry before lawyers, before lawsuits, before the language of victimhood and accountability became so carefully rehearsed. She knew him when the stakes were different. When frustration was vented privately, not framed publicly. When explanations didn't need to align with legal strategy. And that difference, between then and now, is where this chapter lives. According to individuals familiar with the situation, Chelsy did not seek out involvement in this case. There's no indication she wanted her name anywhere near a courtroom or a headline. Quite the opposite, actually. The picture that emerges is of someone who assumed old messages would remain what they were always intended to be, private. But privacy has a half-life, especially when the person on the other end of those messages takes the stand and begins reconstructing the past under oath. At some point, and the exact moment matters, though we'll come back to that, questions were raised about whether Chelsy possessed communications relevant to the trial. Not because she was part of the alleged wrongdoing, not because she leaked anything, but because she may have been told things that now sit uncomfortably alongside sworn testimony. This is where things get delicate. Because there is a difference between accusing someone of lying and observing that their understanding of events evolved or fractured over time. The latter is far more common and far more human. Sources describe the messages in question as unremarkable in tone. No grand revelations, no explosive confessions, just the kind of exchanges people have when they're venting, processing, making sense of chaos. That's precisely what gives them weight. They weren't written to persuade anyone. They weren't crafted to support a lawsuit. They weren't filtered through advisors or legal counsel. They exist, allegedly, in that unguarded space where people speak freely because they believe they can. And in those messages, according to multiple accounts, Prince Harry is said to have acknowledged something that now complicates the courtroom narrative, that at least some of the information reaching the press did not come from journalists digging unlawfully, but from inside the palace itself. Let that sit for a moment. Not because it disproves his case. It doesn't. Even if true, internal leaks don't absolve the press of unlawful behavior elsewhere. These things are not mutually exclusive, but because it reframes intent. If Harry believed, privately, that a former palace aide was responsible for specific leaks, then the decision to frame the press as the primary villain becomes less about discovery and more about emphasis. Again, emphasis is not dishonesty. But in court, emphasis shapes perception. What's striking is not that Harry may have known this. It's that he may have chosen not to foreground it. And before you jump to conclusions, consider why. Imagine you're in his position. You've grown up surrounded by aides, courtiers, systems designed to manage information. You've watched trust erode over years. You've seen stories appear that could only have come from people close to you. You feel betrayed. Not just by the press, but by the institution meant to protect you. Now imagine trying to hold all of that complexity in a courtroom while pursuing a focused legal claim. Do you broaden the narrative, knowing it may weaken your case? Or do you narrow it, believing the broader truth will be lost anyway? This is the dilemma at the heart of Chapter 2. Chelsy Davy's role is not that of an accuser. There is no suggestion she is claiming Harry acted maliciously. If anything, those familiar with her perspective say she has been deeply uncomfortable with how her private communications have become relevant at all. That discomfort matters, because it suggests she didn't preserve these messages as leverage. She didn't curate them. She didn't frame them for future use. They simply existed, dormant, until the present forced a reckoning. And the present, in this case, is unforgiving. As Harry speaks in court about the press's role in his suffering, those messages begin to cast a long shadow. Not because they negate his pain, but because they suggest his understanding of its source may have been more layered than the public has been told. Here's where we need to slow down again. No one is claiming Chelsy Davy leaked these messages to the media. There's no indication she sought to undermine Harry publicly. In fact, the opposite seems to be true. The accounts we have describe a reluctance bordering on resistance, a desire to stay out of it altogether. But reluctance doesn't erase relevance. Once the idea of internal leaks enters the conversation, even privately, it changes the stakes. It introduces alternative explanations. It opens doors defense lawyers are trained to walk through. And it raises a question that cannot be unasked. If Prince Harry knew, at the time, that a palace aide had leaked specific details, why does the courtroom narrative leave that possibility largely unexplored? There are benign answers to that question. Strategic ones, legal ones, but there are also uncomfortable ones. Because if the press was not always the source, then the claim that they continue to come after me takes on a different texture. Not less emotional, just more complicated. And complexity is not something the public is especially patient with. This is where Chelsy's timing becomes critical. The messages are said to date back to periods when Harry was actively dealing with press fallout, when articles were appearing, when frustration was raw. when he was trying to make sense of who he could trust. Those are moments when people speak freely, when they speculate, when they vent, when they assign blame, sometimes accurately, sometimes not. So the presence of these messages does not automatically mean Harry's private assessment was correct. He could have been wrong about the source of leaks. He could have been misinformed. He could have been guessing. But in court, certainty matters. If Harry expressed certainty privately about internal leaks, while expressing certainty publicly about press culpability, that divergence becomes relevant, not because one is false, but because they can't both be complete. Chelsy, by virtue of having received those communications, becomes an inadvertent witness to that divergence. And that's an uncomfortable position for anyone to be in. Imagine realizing that something said to you in confidence years ago might now undermine someone's sworn testimony, not because it was meant to, but because context has changed. Do you speak up? Do you stay silent? Do you hope it never comes up? These are not theoretical questions. They're real ones, faced by people caught between loyalty and obligation. What we know, and what we must emphasize, is that Chelsy has not publicly accused Harry of deception. She has not taken a side in this legal battle. Her role, such as it is, exists largely through the accounts of others and the implications of material she may possess. And yet, that material threatens to shift the ground beneath the trial. Because once private knowledge enters the frame, the court must consider whether omission alters credibility. Not intention, not emotion, credibility. That's the axis on which this case may turn. It's also where things get tense. Because credibility is not binary. It's cumulative, built over time, reinforced or weakened by consistency. If Harry's story to the court aligns with his story to those closest to him at the time, his position strengthens. If it diverges, even subtly, it invites scrutiny. And scrutiny is not kind. At this stage, the messages themselves remain largely unseen by the public. Their contents are described, not displayed. Their context is debated, not settled. But the mere suggestion that they exist, that they acknowledge internal leaks, has already done something important. It has broken the illusion that this is a simple story. And once simplicity fractures, the narrative becomes unstable. That's where we are at the end of Chapter 2. Not at a revelation, not at a conclusion, but at a pivot point. A moment where a person long assumed to be peripheral suddenly occupies a central, if unwanted, role. Where private words begin to matter more than public ones. Where the past refuses to stay quiet. Because if these messages are ever examined closely, line by line, date by date, they won't just tell us what Prince Harry believed. They'll tell us when he believed it. And timing, in a case like this, can change everything. Especially when the next layer isn't about messages at all, but about the calls that followed. The messages don't shout. That's the first thing people who've seen them tend to say. No dramatic language. No panic. No sense that the words were written with any awareness they might one day be read in a courtroom or dissected by lawyers. They read like what they were. Ordinary, private exchanges between two people who believe they were speaking in confidence. And that's exactly why Chapter 3 is where the ground begins to shift. Because when you take emotion out of it, when you stop listening for tone and start looking at timing, stories stop feeling abstract. They become mechanical, almost cold. Dates, times, sequences, the kind of details that don't care who you are or how much you've suffered. This chapter isn't about what was said. Not yet. It's about when it was said and what else was happening at the same moment. According to individuals familiar with the material, the messages attributed to Prince Harry were exchanged during periods of intense media activity. Moments when articles were landing, when headlines were circulating, when pressure was high and trust was low. And crucially, some of those messages predate key publications Harry later pointed to as evidence of unlawful press behavior. That detail matters more than it sounds like it should. Because in court, causation is everything. Who knew what, and when they knew it, forms the backbone of any claim involving intent or wrongdoing. If someone expresses private certainty about the source of a leak before an article appears, that suggests foreknowledge. If they express it after, it suggests analysis or speculation. The difference is subtle, but legally significant. The accounts we have suggest that at least some of these messages fall into the former category. Before publication, before outrage, before legal strategy hardened. And when those timestamps are lined up against the public record, they begin to form a second narrative, one that runs parallel to the courtroom version but doesn't quite intersect with it. Here's what that looks like in practice. An article appears in the press, containing details that feel too specific to be coincidence. Harry reacts privately, venting frustration. That part aligns perfectly with his testimony. No contradiction there. But in some instances, the private reaction reportedly includes acknowledgement that the information came from inside the palace, from someone with legitimate access, not from journalistic intrusion. Again, pause. This does not prove that journalists acted lawfully. It does not absolve the press of anything. It simply introduces an alternative explanation that exists alongside the one presented in court. And courts don't like alternatives unless they're addressed. What makes this especially uncomfortable is that the messages don't appear to hedge. According to those familiar with them, the language is not speculative. It doesn't say maybe or could have been. It points, calmly, toward an internal source. A former aide, someone who, at the time, would not have seemed relevant to a lawsuit against newspapers, but now sits awkwardly in the background of one. This is where narrative momentum slows, deliberately. Because when stories speed up here, they usually go wrong. It's tempting to leap straight to conclusions, to assume intent, to decide that omission equals deception. But that's not how real cases unfold. They unravel through friction, through small inconsistencies that accumulate until they can't be ignored. So let's stay with the mechanics. The messages are said to reference specific incidents, not a general belief that the palace leaks, but particular moments when information moved outward. And in some of those moments, the timing suggests Harry believed the damage was already done internally before journalists ever touched the story. If that's accurate, it raises an uncomfortable question. Why wasn't that belief explored publicly earlier? There are reasonable answers. Harry may have been wrong. He may have suspected an internal leak that didn't actually occur. People under pressure often look inward when trust erodes. Institutions breed paranoia as easily as they breed loyalty. Or Harry may have believed that even if an internal leak occurred, journalists still acted unlawfully in how they obtained or published the information. Again, not mutually exclusive. But here's the problem. In court, clarity matters. If you know of multiple possible sources for a leak, you're expected to acknowledge them, especially when accusing one party of exclusive responsibility. And that's where the timeline becomes less forgiving. Because the messages don't just exist. They sit in relation to other data. Call logs. These aren't transcripts. They don't reveal content. They simply show frequency and duration, who called whom, and when. According to accounts, there are clusters of calls around key moments, after certain articles, before others, patterns that suggest ongoing conversations about what was happening, not one-off reactions. And some of those calls, notably, continue even after the supposed source of leaks had been privately identified. That detail is easy to miss, but it's critical. If you believe you know who leaked information, why continue circling the same explanation publicly without acknowledging that knowledge? Why not pivot? Why not broaden the narrative? Unless the broader narrative served a different purpose. This is where we have to tread carefully. Because intention is slippery. People don't always act in ways that make clean sense from the outside. They act based on fear, instinct, loyalty, and belief. Harry may have believed that internal leaks were a symptom, not the disease. That the press ecosystem created incentives for betrayal, and therefore deserved to be challenged regardless of specific sourcing. That's a defensible position, philosophically, but it's a risky one legally, because philosophy doesn't stand up to cross-examination. Timelines do. Imagine a defense lawyer standing up and asking a simple question. When did you first believe the information was coming from inside the palace? Not accusing, just asking. And imagine the follow-up. Did you share that belief with anyone at the time? And then, inevitably, why was that belief not reflected in your public statements or your legal filings? Those questions don't require hostility. They don't require shouting. They simply require dates. That's why Chapter 3 is so destabilizing. Because once the timeline is introduced, emotion loses its dominance. Facts start to press in from the edges. And the timeline doesn't belong to anyone. It's not loyal. It doesn't care about narrative arcs or moral clarity. It just is. What complicates matters further is the apparent consistency of the private messages. According to sources, they don't contradict themselves. They don't shift blame from day to day. They suggest a stable belief, at least for a period, that the leaks were internal. Stability is persuasive, even when it's wrong. If Harry held that belief consistently in private, it strengthens the argument that it was genuine. But it also strengthens the argument that it should have been acknowledged publicly. And that's where the gap opens. Not a gap in honesty, a gap in disclosure. And disclosure is what courts are designed to extract. This is also where Chelsy Davy becomes more than a passive figure. Because the messages weren't sent into a void. They were received, read, responded to. She becomes, unwillingly, a time-stamped witness to Harry's private understanding of events. Not his pain, his understanding. Those are different things. Pain can coexist with misinterpretation. Pain can persist even when its cause is misidentified. Courts recognize this. But when legal claims hinge on attribution, on who did what, misidentification becomes relevant. And relevance is the currency of litigation. What's striking is how ordinary the exchanges reportedly are. No legal jargon, no framing, just frustration, resignation, and the quiet recognition that something inside the system had gone wrong. That ordinariness is dangerous, because it undermines the idea that these messages were strategic. They weren't crafted to serve a future case. They predate it, which means they're harder to dismiss. At this point in the story, nothing has been proven. No judge has ruled. No document has been authenticated publicly, but the timeline exists, and it's being examined. Slowly, methodically, without drama. And that's how the most consequential revelations usually emerge, not with a bang, but with a spreadsheet. This is the moment where the story stops being about headlines and starts being about sequencing. What happened first? What followed? What was believed privately? What was said publicly? And what was never said at all? As this chapter closes, the focus shifts again. Because messages establish belief. Timelines establish knowledge. But the next layer, the one that truly tests credibility, isn't about texts. It's about the calls that followed them. The ones that suggest the conversation didn't end with a single realization, but continued, deepened, and perhaps even hardened into certainty. And once certainty is established privately, the burden of explanation grows heavier. Especially when that certainty never makes it into the witness box. The call logs don't tell you what was said. They don't capture tone, or hesitation, or whether someone sighed before answering. They don't show anger, or relief, or confusion. They don't record who interrupted whom, or whether a sentence trailed off unfinished. All they do is sit there. Rows of dates, times, durations. And that's why Chapter 4 is the point where this story becomes genuinely uncomfortable. Because when you lay the calls next to the messages, not emotionally, not narratively, but mechanically, a pattern starts to emerge. And patterns don't need interpretation to exist. They only need repetition. According to people familiar with the records, the calls attributed to Prince Harry cluster around specific pressure points. Not randomly, not evenly spaced, but tightly grouped around moments when stories appeared or were about to. This isn't unusual on its own. Anyone under scrutiny talks more when the scrutiny intensifies. That part is human. What makes this different is what the calls appear to follow. In several instances, the messages acknowledging internal leaks come first. Then the calls begin. Short calls at first. A few minutes. Sometimes unanswered. Then longer ones. Then multiple in a single day. As if something unresolved needed to be talked through again and again. The timing suggests these weren't casual check-ins. They look like conversations that mattered. And here's where the narrative starts to tilt. Because if Harry had privately concluded, even tentatively, that certain leaks came from inside the palace, these calls may represent the period where that realization was processed, tested, revisited, maybe even reinforced. This matters because the calls don't stop after that realization. They continue, which raises a question that's hard to ignore. If you believe you know the source of a leak, what are you still trying to understand? One possibility is doubt, second-guessing, the hope that you're wrong, that there's another explanation that hurts less. Another possibility is strategy, figuring out what to do with that knowledge, whether to confront it, ignore it, or compartmentalize it. And then there's a third possibility, the most uncomfortable one, that the internal explanation and the public explanation began to diverge. Not accidentally, but intentionally, because each served a different purpose. Again, intention is not accusation, but divergence is observable. The call logs, according to those who have reviewed them, show sustained communication well beyond the initial shock phase. This wasn't a single emotional reaction. It appears to be an ongoing dialogue, which means the idea of internal leaks wasn't fleeting. It didn't come and go. It lingered, and lingering beliefs have consequences. Now, consider this in light of what the court has heard. In testimony, Harry presents a clear through line: unlawful press behavior as the primary engine of harm. The story is coherent, focused, legally efficient, but the call pattern suggests his private processing of events may have been less linear, more conflicted, more human. There's something else about the calls that complicates matters further. They don't taper off when legal action begins. In fact, in some accounts, they intensify around the period when litigation strategy is being shaped, when claims are being refined, when narratives are being formalized. This is the point where lawyers would typically urge clients to stop discussing sensitive matters outside privileged channels, to limit exposure, to avoid ambiguity. Yet the calls continue, which implies one of two things. Either these conversations were not perceived as risky, meaning Harry did not believe the internal leak explanation threatened his case, or he believed the private truth could be safely separated from the public one. Neither option is legally comfortable. If the internal explanation wasn't seen as a threat, that suggests Harry believed it could coexist with his claims against the press. That internal leaks and unlawful journalism were both at play, even if only one was emphasized. If the explanation was seen as risky but compartmentalized anyway, that raises questions about selective disclosure. Again, not about lying, about framing. And framing is everything in court. What makes Chapter 4 particularly delicate is that call logs are difficult to dismiss. You can argue about interpretation. You can argue about intent. But you can't argue with their existence. A call happened, or it didn't. And when calls happen repeatedly, at moments of heightened stress, they imply that something unresolved is being worked through. This is where Chelsy Davy becomes central again, not as a participant in wrongdoing, but as a witness to Harry's internal narrative as it evolved. She isn't alleged to have directed his thinking. She isn't accused of shaping strategy. She simply appears to have been someone he trusted enough to speak freely with when things felt out of control. That trust is what gives these interactions their weight, because people don't usually rehearse public narratives with those they trust. They reveal doubts. They vent contradictions. They test ideas before deciding which ones to carry forward. And the call logs suggest this wasn't a one-time release of frustration. It was a process unfolding in parallel with the construction of a legal case. Now, imagine how this might look under scrutiny. A defense attorney doesn't need to prove that Harry was wrong. They only need to show that he knew of alternative explanations and chose not to foreground them. That's enough to introduce doubt. Enough to ask whether the court has been presented with a complete picture. And courts are allergic to incompleteness. What complicates this further is that Harry's emotional testimony about Meghan Markle functions as a kind of moral anchor. It draws attention, understandably, to the harm experienced, not the mechanics of how that harm occurred. Emotion, in that sense, becomes a shield, not deliberately wielded, but effective nonetheless. It's hard to interrogate timelines when someone is describing pain. Hard, but not impossible. Judges are trained to do exactly that. And if the call suggests that Harry's private certainty about internal leaks solidified before or during the period covered by his claims, the court may have to ask whether emotional truth was allowed to eclipse factual nuance. This is not about undermining his suffering. It's about separating suffering from attribution. One can be genuine while the other remains incomplete. Here's another detail that matters. The calls don't appear to be reactive only. They're not all placed immediately after articles appear. Some come hours later, others the next day. A few even precede publications. That timing suggests anticipation, not just response. Which raises a subtle but critical question. Was Harry bracing for leaks he believed would come from inside the palace, even as he publicly positioned the press as the threat? If so, the narrative tension becomes unavoidable, because anticipation implies knowledge, or at least expectation. and expectation, once documented, becomes something lawyers circle. At this stage, nothing has been ruled admissible or inadmissible. No call log has been formally presented in court. No message has been authenticated publicly. But the existence of this pattern is enough to shift how the story is understood by those watching closely. This is no longer a simple case of press versus prince. It's a case about how people process betrayal, and how that processing shapes the stories they later tell under oath. Harry may have believed that internal leaks were an unfortunate reality, but not the core injustice. He may have believed the press ecosystem still deserved to be challenged for its role in amplifying and exploiting those leaks. That belief could be sincere, but sincerity doesn't erase the obligation to disclose competing explanations when they're known. And that's where the silence becomes louder than the testimony. As Chapter 4 closes, we're left in a narrow, uneasy space. Not between truth and falsehood, but between two truths that don't quite align. A private truth, worked through in late-night calls and unguarded messages, and a public truth, delivered carefully in a courtroom, shaped by legal necessity and emotional urgency. Sooner or later, those two truths have to meet. And when they do, the question won't be whether Prince Harry was hurt. The question will be whether he allowed that hurt to simplify a story that was, from the beginning, far more complicated. Because the next layer doesn't just involve who knew what. It involves what happens when emotional testimony becomes a strategic shield, and whether courts are willing to look past it. And that's where this case may change in ways no one is ready for yet. The word lands softly in the courtroom. Misery. Not shouted. Not dramatized. Just spoken, almost carefully, as if Prince Harry is testing whether it can bear the weight he's about to place on it. They have made my wife's life an absolute misery. When he says it, the room reportedly stills. Lawyers stop scribbling. The public gallery leans forward. Even the air seems to pause, as if aware that something fragile has entered the record. This is where Chapter 5 begins. Because once that word is spoken, everything else rearranges itself around it. Up to this point, the trial has been about conduct, about sourcing, about legality, about whether Associated Newspapers, through the Daily Mail and the Mail on Sunday, crossed lines they were never entitled to cross. But misery is not a legal standard. It's an emotional one. And once it enters the room, it changes how everything else is heard. Harry's testimony, by all accounts, becomes more personal here. Less about systems and more about people. About watching someone he loves struggle under relentless attention. About fear, isolation, and the sense that no matter where they turned, the pressure followed. And this is where Meghan Markle becomes central, not as a litigant, not as a defendant, but as the emotional lens through which the alleged harm is now viewed. The narrative shifts subtly but decisively. This is no longer just about Harry. It's about what he says happened to her. And that shift matters more than it seems. Because once emotional harm is foreground, it becomes harder to interrogate mechanics without appearing callous. Questions about timelines, sources, and alternative explanations start to sound, to some ears, like distractions from suffering. That's not an accident. It's how human empathy works. And courts are staffed by humans. Harry describes a pattern of coverage that he believes targeted Meghan unfairly. He speaks about the cumulative toll. Not one article, not one intrusion, but the slow erosion of safety and peace. He frames the press as relentless, indifferent to consequences, and unmoved by appeals for restraint. In doing so, he invites the court and the public to see the lawsuit not merely as a technical dispute, but as a moral one. And again, this framing resonates, because many people watching already believe the media has a long history of crossing ethical lines. Harry's testimony slots neatly into an existing critique. It feels familiar, plausible, even overdue. But here's the tension that Chapter 5 refuses to let go of. Emotional truth and factual completeness are not the same thing. They often overlap, sometimes perfectly, but when they diverge, courts have to decide which one governs. Harry's description of Meghan's misery may be entirely accurate. The stress, the fear, the sense of being hunted. Those experiences do not require unlawful journalism to exist. They can be real regardless of sourcing. And that's the uncomfortable part. Because if internal leaks contributed to that misery, even partially, then focusing exclusively on the press doesn't negate the harm, but it does simplify its origin. And simplification is where credibility risks begin to accumulate. This is not about blaming Meghan, or minimizing her experience, or suggesting that press behavior was harmless. None of that follows. It's about whether the emotional centerpiece of the case has become a kind of shield, not intentionally wielded, but powerfully effective, against questions that feel too cold to ask once suffering has been laid bare. Consider how this plays out in real time. A defense lawyer stands up after such testimony. The room is still echoing with the word misery. The public mood is sympathetic. The claimant is visibly emotional. Now ask yourself, honestly, how easy would it be to pivot from that moment to a question like, were you aware, at the time, that some of this information may have come from inside the palace? It's not an impossible question, but it's a risky one, because it sounds, on the surface, like an attempt to redirect blame away from the press and toward the institution Harry has already distanced himself from. And that redirection can be framed, unfairly or not, as deflection. This is why emotional testimony is so powerful. It narrows the space in which alternative explanations can comfortably exist. Harry's account of Meghan's misery is compelling because it's not technical. It's relational. It's about watching someone you love suffer and feeling powerless to stop it. That kind of testimony doesn't invite spreadsheets. It invites solidarity. But the law does not operate on solidarity alone. And here's where the chapter tightens. Because if Harry privately believed that internal actors contributed to the leaks that caused this misery, the question becomes not whether the misery was real, but whether the attribution of its cause was selectively framed. Again, selective framing is not lying. It is, however, something courts care deeply about. This is where the alleged private communications loom larger. Not because they contradict Harry's emotions, but because they suggest his understanding of causation was more complex than the court has been shown so far. And complexity, once acknowledged, demands disclosure. Imagine two truths existing side by side. Truth 1. Meghan experienced profound distress as a result of media coverage. Truth 2. Some of the information fueling that coverage may have originated internally. Both can be true, simultaneously, but if only one is emphasized repeatedly, emotionally, and publicly, the omission of the other becomes relevant. Not morally, legally. This is where the idea of an emotional shield becomes unavoidable. Not a conscious strategy, not a manipulation, but a dynamic where genuine pain makes it harder to ask hard questions and easier to accept simplified narratives. Harry's testimony invites the court to focus on impact over process, on harm over mechanics. And again, that makes sense from a human standpoint. But courts are not therapy sessions. They are instruments designed to allocate responsibility. And responsibility requires specificity. Who did what? How? When? And with what knowledge? When Harry speaks about Meghan's misery, he is asking the court to accept that the press's actions were the primary driver of harm. He is not, at least publicly, parsing the degree to which internal dynamics may have played a role. And that absence now sits uncomfortably alongside the alleged private acknowledgments. Because if he knew, or believed, that internal leaks were happening, then the emotional centerpiece of the case becomes less about discovery and more about emphasis. Emphasis on the press, silence on the palace. Why? There are charitable explanations. Harry may believe that internal leaks are inevitable in any institution, while unlawful journalism is not. He may see the press as the amplifier that turned private betrayals into public trauma. In that view, the press remains the appropriate target. That's a coherent argument. But it's not the argument that has been fully articulated. And courts do not infer arguments that are not made. They weigh what is presented. This is where Chapter 5 leaves us in an uneasy place. Because the emotional power of Harry's testimony about Meghan is undeniable. It humanizes the case. It reminds everyone that real people are affected by these disputes. But it also raises the stakes of omission. Once you place misery at the center of your claim, you implicitly assert a clear line of causation. And if that line is more tangled than acknowledged, the court will eventually want to see the knots. And the court will not be alone. Public opinion, too, has a way of shifting when it senses that emotional narratives have outpaced factual disclosure. That doesn't mean sympathy evaporates. It means scrutiny intensifies. As this chapter closes, the trial stands at a delicate balance. On one side, an emotionally compelling account of harm, vivid, sincere, and deeply personal. On the other, a growing body of indications that the story of how that harm occurred may be more layered than the courtroom has yet explored. The emotional shield is strong, but shields are only effective until someone looks behind them. And the next phase of this story isn't about feelings at all. It's about what happens when the defense begins to probe the gaps, not aggressively, not cruelly, but methodically, and asks whether the court has been shown the full picture. Because once credibility is questioned, even gently, it doesn't collapse all at once. It erodes. And what comes next may depend less on how much pain was felt and more on how much truth was left unsaid. They don't rush it. That's the first thing worth noticing. When Chapter 6 begins, nothing dramatic happens in the courtroom. No raised voices. No sudden objections. No theatrical pauses designed for the gallery. If you weren't paying attention, you might miss the shift entirely. But the defense has changed gears. And once you see it, you can't unsee it. Up to this point, the case has lived in broad strokes. Big ideas. Big emotions. Big themes. A prince versus a press empire. Pain versus power. Harm versus accountability. Now, the defense starts doing something far less visible and far more dangerous. They begin to narrow. Not the narrative. The questions. This is where the phrase, "what the defense didn't expect," stops being about surprise witnesses or secret documents and starts being about something subtler, opportunity. Because defense teams don't need explosions to win cases. They need openings. And the opening here isn't Chelsy Davy herself. It isn't the messages. It isn't even the call logs. It's the space between them. That space, the gap between what was privately acknowledged and what was publicly asserted, is where Chapter 6 lives. If you imagine this case as a structure, the emotional testimony has been the facade. Impressive, convincing, hard to challenge without looking cruel. But legal cases aren't demolished from the front. They're tested at the joints. And one of those joints is credibility. Not whether Prince Harry is sincere. Not whether he is hurting. But whether the court has been given a full and accurate account of what he knew, and when he knew it. Defense lawyers are trained to think in timelines, not narratives. They don't ask, what story feels right? They ask, what story can survive cross-examination? And this is where the alleged private material becomes more than uncomfortable background noise. It becomes leverage. Because leverage doesn't require proof beyond doubt. It requires plausible doubt. Imagine the defense approaching this not head-on, but sideways. They don't accuse Harry of deception. That would backfire. It would alienate the court. It would look aggressive in the face of emotional testimony. Instead, they ask questions that sound almost sympathetic. Questions like, when you first became aware that information may have been coming from within the palace, how did that affect your understanding of the situation? Not accusatory, reflective. Or, did you consider the possibility that multiple sources contributed to the coverage you found distressing? Again, reasonable, even generous. The power of these questions isn't in what they assert. It's in what they allow the court to consider. Because once multiple sources are acknowledged, the causal chain Harry has presented begins to loosen. Not break. Loosen. And loose threads are what defense teams pull. Here's why this matters more than it seems. Harry's case, as presented, relies heavily on the idea that unlawful press behavior was the driver of harm. Not the sole contributor, perhaps, but the central one. The engine. If the defense can show that Harry privately believed internal leaks were responsible for at least some of the most painful disclosures, then the press becomes, at minimum, a secondary actor in those instances. That doesn't mean they're innocent, but it does mean they're no longer the exclusive cause. And exclusivity matters in law. Now consider the strategic restraint here. The defense doesn't need Chelsy Davy to testify. They don't need to parade private messages in open court, at least not yet. They don't need to prove that internal leaks were real, only that Harry believed they were. Belief alone is enough to introduce reasonable doubt about attribution. That's the quiet brilliance of this approach. Because it turns Harry's own internal processing into a question mark over his public claims. Not because he was wrong, but because he may have known there was more to the story than the court was shown. This is also where the defense's expectations begin to shift. According to legal observers, Cases like this often hinge on whether claimants present themselves as seekers of truth or advocates for a cause. Both are legitimate positions, but they carry different burdens. If Harry is seen as seeking truth, even when it complicates his case, his credibility strengthens. If he's seen as advocating for a cause by streamlining facts, credibility becomes more fragile. The alleged existence of private acknowledgments tilts that balance. Again, we need to be precise. There is no indication that Harry set out to mislead the court. None. That's not what's being suggested here. What's being examined is whether his testimony reflects his full understanding of events at the time they occurred, or a later, consolidated version shaped by legal necessity and emotional coherence. Those are not the same thing, and courts are very good at spotting the difference. The defense also has another advantage here: silence. Chelsy Davy has not spoken publicly. She hasn't contradicted Harry in the press. She hasn't given interviews or issued statements. That silence makes it harder to dismiss her relevance as opportunistic or malicious. If anything, it makes the material attributed to her seem more credible, not less. Because people who seek attention usually speak. People who don't usually didn't want to be involved in the first place. That distinction matters when judges weigh whether potential evidence is being manufactured or reluctantly surfaced. This is also the point where the defense's expectations shift internally. They may have expected to fight a case built on outrage and precedent. Phone hacking, tabloid misconduct, historical wrongdoing. That's familiar terrain. What they may not have expected is a case complicated by the claimant's own private doubts. Doubts that don't negate harm, but muddy its source. And muddy sources are fertile ground for defense arguments. Think about how this plays out procedurally. The defense doesn't need to win the narrative. They just need to weaken the claimant's certainty. Once certainty is weakened, the burden subtly shifts. Instead of the press having to explain how they obtained information, Harry may be asked to explain why alternative explanations weren't disclosed. That's a profound reversal. And it happens without theatrics. This is where Chapter 6 takes on its slow burn quality. No fireworks, just gravity. The gravity of knowing that once a court begins to question completeness, everything that follows is viewed through a different lens. Even emotional testimony, especially emotional testimony, because emotion can persuade, but it can also distract. And judges are trained to ask whether they're being asked to feel something instead of see something. This is where the defense may lean hardest into restraint. They don't challenge Harry's pain. They acknowledge it. They validate it. And then they pivot, not to accuse, but to clarify. What else did you know? When did you know it? Who did you tell? These questions don't attack character. They interrogate process. And process is where inconsistencies live. At this stage, the defense doesn't need answers. They need hesitation, a pause, a clarification, a qualification. Even a moment of uncertainty can be enough to plant doubt. And doubt, once planted, grows.